Thank you, Mr. Sami.
Thank you, Lord. Ms. Baba, I give the court respond to you.
May it please the court, my lord, my surname is Vilankulo and I'm appearing for the 6th and 7th respondent.
Thank you. This matter was argued before us last week over a period of 2 days, and we reserved a judgment until today. This court has carefully considered the weighty arguments advanced by the parties in the limited time available given the urgency of the matter. There are 3 judgments. The first judgment concludes, for reasons set out therein, that the President has not made out a case for an interim interdict. It proposes that the application be dismissed. The second judgment concludes that the President has made out a case for an interim interdict for the reasons set out in that judgment. It proposes that an interdict of a limited duration be granted. The third judgment concurs with the second judgment. The second judgment is the majority judgment. In the result, the following order is made. 1. Pending the determination by this court of the applicant's review under case number 2026/119192, the first and second respondents are interdicted from proceeding with the public impeachment hearings in terms of Rule 129 M of the National Assembly Rules. 2. The cost of the application shall stand over for determination by the court which hears the review. The judgment will be made available on case lines and safely shortly after we adjourn this court. That is our judgment, and we will then adjourn. Court adjourns.
This one. This one. With the stick. Where's mine? They show me. On the wireless.
Thank you.
We are, I am part of the impeachment committee. We are represented as the IFP. But what we can say about today's outcome is that the IFP notes the decision of the Western Cape High Court to grant the urgent interdict application relating to the ongoing Section 89 impeachment inquiry. As a party firmly committed to constitutional democracy and the rule of law, I, under the IFP, respect the judgment of the court and the independence of the judiciary. We believe that while the ruling may temporarily affect the continuation of the Section 89 process, it does not diminish Parliament's constitutional obligation to exercise oversight and ensure accountability in accordance with the Constitution and applicable legal processes. I would also want to say that the IFP will carefully study the judgment and its implications for the work of the impeachment committee and will continue to participate constructively in any subsequent parliamentary processes subject to the court's directives. We remain committed to ensuring that all constitutional processes are conducted lawfully, fairly, and with due regard for the integrity of Parliament and the constitutional rights of all parties. And lastly, the IFP will continue to support the principle that accountability and constitutional governance must always prevail within the framework of the law.
Result you anticipated. What now?
We are going to read the judgment, find out exactly what have they stopped. Is it the entire process or the hearings aspect of the process? Like, can we continue nominating or deciding the evidence leaders, terms of reference, having the independent panel come, table the report? What exactly has been stopped? We're going to find out once we read the judgment.
And that's an important part, because my reading into the words that was used by the presiding judge was that the committee is precluded from a public impeachment hearing. So it seems as though the administrative work may still well continue. And of course, there is that deadline that exists today for parties to make their final submissions on that. Does this in any way, this judgment, change your approach to how you'll be going forward in terms of your work in the impeachment committee?
The judgment, once we read it, we are going to have a full understanding. However, today we are going to continue submitting our names, and we are expecting that next Wednesday we are going to decide and agree on the terms of reference. However, what becomes very tricky now, without reading the judgment, of course, is that can we proceed with the questions of having the other aspects of the preparations in terms of getting the independent panel coming to table the report, getting some aspects, or is it a case whereby the president himself cannot come to the witness stand, but the other people that the committee would want to get evidence from can actually come? So we're going to wait, read the report, but consult our lawyers so that we push this question of accountability, because the reason why we are here is that there is misconduct on the side of the president, which has been affirmed or confirmed by independent panel of experts, and it would be failing South Africans as members of parliament if we don't get evidence, we don't get the truth and answers when it comes to having an inquiry.
Yeah.
Well, I think it was reasonably predictable, given all the circumstances. It's strange that there are these three judgments, and the first one you didn't meet the benchmark, and second two you did, so I'm looking forward to reading them. It's difficult to comment on the reasoning without having read the judgments, and they're not yet available. It's a very important decision for the separation of powers, and it needs to be studied very carefully. But, it doesn't stop the committee from doing its work. We can do the administrative work. We can appoint the evidence leaders. We can finalize the terms of reference. We can settle the witness lists. And the presiding judge said we're interdicted from public hearings. Well, that doesn't mean that we're interdicted from hearings in camera, so we'll have to have a look at that. But it's hard to comment on the reasoning unless you've read the actual judgments. But we find ourselves in a position where a president has had to go to the courts to stop to stop Parliament from doing its job, which is a bizarre set of circumstances, and really not a place that he should want to find himself in. So for him, it's a loss, whatever happens.
The president made arguments here that not only did he have a right to an interim interdict, given that the Section 89 panel report is under review in the review court, but more importantly that it was that he would be unduly and unfairly prejudiced should the impeachment work go ahead. While that is still under review, because if the outcome of the review court is that the Ngcobo report is invalid, unconstitutional, and should be set aside, that the president would have been prejudiced by that. And you account for that to be quite a bizarre move by the president.
Well, it's a bizarre set of circumstances that you have a whole president of a country who needs to approach the courts because on his own version, he doesn't want to be publicly embarrassed. How he finds himself in this situation is, of course, his own fault. And so it is bizarre that he finds himself in this position. I mean, who keeps their money in their couch?
Importantly here, Glynis, is also the question around the review application. The president makes the argument there that the Ngcobo panel had misdirected itself in that matter. That will be heard in early September, and given that it's also on an urgent basis, judgment will then follow soon thereafter. Your thoughts on that?
Yeah, look, a lot depends on what that outcome is, but we're at the end of July. So basically we're looking at August and September, and then whatever happens, we either interdict it then, well, otherwise it either falls away completely and there's nothing to do, or we are then make sure that we're in a position to start immediately and carry on with it, which I think will be the case. So we need to get ourselves ready, and you know, as you say, it's a weird set of circumstances where a president has to approach one arm of government to interdict another arm of government from doing his job because he doesn't want to be publicly embarrassed. He shouldn't.
Committee's reaction to this?
No, we are very happy with the judgment. This is what precisely we have said to the committee, that let's abide and not oppose the interdict by the president, because we believe that the president, like anyone in the country, has got the right to sought relief where he feels that his rights are impeded upon. So we're very happy with the outcome of the judgment.
Surely some members of the committee had good reason to think to go ahead, given that at least one of the judges of the three on the bench believed that the president did not make out a case for it. Of course, the majority judgment rules on this instance, but the wording there was very specific, Mika. It very specifically said that it precludes the first and second respondents, Parliament and the impeachment committee, from going ahead with a public hearing of an impeachment process. It doesn't preclude it from doing any other work related to the impeachment process just yet.
Yes, and it covers a lot of things that the opposition parties were already going into, like calling for the president to be the first witness that they wanted to do, because they wanted to change this thing into a political football. And we have always said that this is the president of the country, this is number one office in the country. We've got to act in a manner that is fair and impartial. We don't need to have this as a political football. And this is where we are. Opposition parties have a responsibility to oppose what the ruling party is doing. We didn't expect less from them. That's what they did, and it's what they did. We can't do anything about that.